So I see that it is 7 o'clock and I am mindful of everyone's time. So I will get us started. Good evening. Thank you so much for joining us. My name is Melanie Jacobs. I have the privilege of serving as the interim dean at the Michigan State University College of Law. And I am really delighted to introduce our third speaker as part of, or our third program as part of our newly launched faculty speaker series. But really delighted to have with us this evening Professor Brian Gilmore. So Professor Gilmore is the director of the Housing Clinic here at MSU College of Law. He is also the interim director of the Frank Kelly Institute for Law and Ethics. Professor Gilmore is a law professor, advocate, writer, and poet. Prior to joining the MSU College of Law faculty, Professor Gilmore had been on the faculty at Howard University in Washington, D.C., where he also was a clinical professor, supervising attorney with the Clinical Law Center. And while there, Professor Gilmore developed and initiated the Fair Housing Teaching Program and organized many programs to educate local constituents and community advocates on relevant legal topics, and designed a housing law and the public interest course. Prior to that, he had spent 15 years in practice, including working for Neighborhood Legal Services and the Washington Legal Clinic for the Homeless. Professor Gilmore has many credits to his name, many scholarly credits, legal law review articles, bar journal articles, and so forth. But I think it's also worth noting he has 4 published volumes of poetry. His most recent is Come See About Me, Marvin, which was a 2020 Michigan Notable Book, which I think is fabulous. And in that collection, Professor Gilmore creates a dialogue between himself and Marvin Gaye, 2 Black men born in the nation's capital, but who moved to the Midwest for professional reasons. So in addition to the 4 published volumes of poetry, Professor Gilmore's writings have also been in the Washington Post and the ABA Journal, The Nation, the Baltimore Sun. I encourage you to take a look at his bio. The last thing I will just say is that honestly, I don't know how he finds enough hours in the day to do all that he is doing, to do the work of a law professor, a legal advocate, a community advocate, scholar, poet. And we were talking before the webinar officially began, and his daughter was in the room, so also a husband and a father. But somehow he does it, and as you'll notice, he always does it with a smile. He is a fabulous colleague, and I'm really, really excited for you to hear from him this evening. So thank you very much, Professor Gilmore, for joining us. And just a reminder, the way the format will work is that Professor Gilmore will speak for roughly 20 minutes or so. Then we'll move on to the Q&A. I will moderate that. So please put questions in the chat, and that way I will be able to read the questions and we'll have them for our recording. So I'm going to turn my camera off briefly so that the spotlight is on you. Professor Gilmore.
Thank you very much, Dean Jacobs, Melanie. Thank you again, Sally Rice, who has been very instrumental in a lot of things lately, the Kelly Institute lecture, and now this. So it is most appreciated, and I appreciate everyone else to come check this out tonight. And especially to my former and current students, if you are in attendance, thank you very much, because the answer to one of the questions that Dean Jacobs stated, how do you do the work, is, I mean, a lot of it is because of the hardworking students who are energetic and really want to learn how to be an advocate, but also try to address problems in society and the greater good. And those who've been in the clinic know that it's, most of all, we try to do it and have a good time. Terrible things going on, but we try to have a good time. So I'm going to talk briefly tonight about how COVID-19 has been working in the rental housing sector and the eviction world, where I've been in since, as Dean Jacobs suggested, since the 90s. I got my first housing case in like 1993, and I was representing a woman in public housing who and drug dealers had taken over her apartment by force, and became her lawyer to get her moved into another place, and to also get the agency to admit their role in allowing that to happen. So I've been doing this for a long time in 3 different jurisdictions, and they're all different. Michigan has been quite a ride so far for the last decade or so. But I'm going to talk about the COVID-19 crisis that's still ongoing and the various things that happened. Most of you all know it was a pretty unique crisis, and been doing some writing on it as well. So I'll read some of the text of what I've written and make some other comments, and then we can open it up for any discussion you want. Hopefully 1 or 2 of the questions that are being asked might be answered as I go through this text here. But my hope is to turn it into a law review article or maybe something else as well. So when the COVID-19 crisis hit, not only were there individuals being sued for eviction who were there because of poverty and existing economic struggles, but now there was another swath of tenants being sued who had lost their source of income due to COVID-19. When the lockdowns occurred all across the country, more and more individuals and families found themselves subsisting on just unemployment and the relief the government provided. This was quite unprecedented because the unemployment could not replace the lost income. Due to the loss of income and the threats of eviction in states all across the country, many states issued temporary moratoriums on evictions in their states. Nearly every state at some point, and even some cities, issued moratoriums on evictions in the early weeks of the spread of the virus in 2020. However, by April, some resistance to these blanket moratoriums had begun. It was readily apparent that evictions were concentrated, as was the virus, in densely populated areas of the country. America's urban centers greatly needed eviction slowdowns. Other rural areas and other areas with less population were not as receptive to the moratoriums. By July, while the numbers of evictions filed had declined, it was still being reported that 23 million people could face evictions. The numbers likely declined due to the various measures taken by state governments to slow down the evictions. On September 4, 2020, as COVID-19 continued to spread, the federal government took action again to try to address the problem. The Center for Disease Control issued a temporary halt of all evictions in the United States in certain cases to prevent the spread of COVID-19. Tenants who were facing potential evictions had to execute an affidavit that demonstrated the following. The individual has used best efforts to obtain all available government assistance for rental housing. The individual could not earn more than $99,000 in annual income for the calendar 2020. The individual is unable to pay full rent or make a full housing payment due to substantial loss of income or loss of compensable hours of work or wages, or layoff. The individual is using best efforts to make timely partial payments that are as close to full payment as possible. And the eviction would likely render the individual homeless or force the individual to move and live in close quarters in a new congregate or shared living setting because the individual has no other available housing options. If the tenant demonstrated the above criteria, they likely could avoid an immediate eviction, or at least until expiration of the order on December 31st, 2020. Since the initial federal moratorium, the moratorium has been extended several times. it has also been true that landlords have not stopped seeking evictions. In fact, some of the legal challenges have been successful and have further challenged the existing patchwork of eviction moratoriums. In addition, some landlords have managed to evict tenants anyway, using other tactics. These developments have been destructive to the overall response to the virus. Michigan acted very responsibly. While Governor Whitmer initially took action, the state Supreme Court was also even more proactive. The state's landlord-tenant docket was allowed to reopen, but it would be reopened in a responsible manner and with some controls in place to reduce evictions. First, the court required the cases scheduled in a staggered fashion, with the cases pending the longest to go forward. In addition, limits were placed on the number of cases that the courts could schedule. The court also altered the normal procedure of landlord-tenant cases. The court added a pretrial date to all landlord-tenant cases, and renters were advised of their right to counsel and their right to seek rental assistance through Michigan's social services agencies. Those funds were provided by various sources: private, state, city, county, and federal. It also helped that many jurisdictions in Michigan already had in place an eviction diversion program. This is the program Michigan State University College of Law has participated in since 2013. Michael Syracuse, former staff attorney here and now legislative counsel in the Michigan legislature, helped set the program up while he was here. This program allows tenants to receive rental assistance and pro bono legal representation from Legal Services of South Central Michigan and the MSU Housing Law Clinic. Two studies already have shown that since the program began, the eviction rate and the judgment rate in cases in Michigan has declined. Two other cities, Richmond and Durham, North Carolina, have consulted with our clinic and have started very successful programs in their cities. With all of this said, it is safe to say that the actions of the Michigan Supreme Court to take direct action at this difficult time has been very beneficial to hundreds, perhaps thousands of Michigan renters. And the court has not stopped its focus either on the problem. 1 month ago, it issued another order. If a tenant sued for eviction has applied for rental assistance through the new CERA program, CERA stands for the COVID Emergency Rental Assistance Program, and that is the latest rental assistance program that has been formed to address the problem. So through the new CERA program, their cases stayed automatically for 30 to 45 days to process payment to the landlord and then have the case dismissed. Our clinic, I'm happy to say, has been in the crosshairs of this public health crisis from the beginning. With the resources of the university, the support of the law school's leadership, and with the energy of the law students in the clinic, we probably have processed 5 to 15 agreements to avoid eviction and to pay back rent since late July 2020 every week. We are now planning to enter the new phase of the process as tenants can now apply for the new CERA program benefits on their own through an automated website. While the strain on anyone's eyes during Zoom court has been rough, and the impersonal nature of being in the matrix, that's what I call it, 3-4 days a week for court is a bit disconcerting. This is why I went to law school. This is why I became a legal services attorney many years ago in Washington, D.C. This is also why I decided to do clinical legal education to help people at their most challenging moments. Okay, so why is all of this important? While a lack of housing presents possible health consequences under non-pandemic conditions, the arrival of the novel coronavirus created even more serious health issues for renters. In fact, it was demonstrated during the pandemic that evictions exacerbated the spread of the virus amongst the public. Multiple studies, both directly related to the spread of the virus and the effects of the virus on daily life demonstrate the problems created by evictions during the pandemic. 43 states and the District of Columbia participated in one study. According to the study, quote, incident rate ratios and mortality rate ratios remain constant. However, once the moratoriums were lifted, the incident ratios increased to various levels. In addition, mortality rate ratios significantly increased as well following the lifting of the eviction moratoriums. According to this study, the lifting of the moratoriums and allowing evictions to begin again resulted in 433,700 cases and 10,700 deaths nationally. The study also concluded that because the incident ratios increased, the longer the moratoriums have been lifted, this strongly suggests that the effects of evictions, homelessness, displacement, and housing overcrowding were exacerbated by the lifting of the moratoriums. A second study conducted roughly at the same period reached similar conclusions on the issue of COVID-19 and rental housing evictions. According to this second study, evictions drive increases in COVID-19 cases across cities. The study carefully examined multiple cities and their evictions patterns, and determined that evictions place individuals at an elevated risk of infection, but also residing in overcrowded households as a result of evictions. While these studies continue and are under peer review currently, the results and conclusions are very specific in nature. The results of the study suggest that the CDC mandated national order prohibiting evictions from September 4 through December 31st, 2020 likely prevented thousands of excess COVID-19 infections for every million metropolitan residents. In addition, the simulations used in the study showed that allowing evictions would increase the relative risk of infections for all households, not just a narrow class of those experiencing eviction. Despite this kind of information, responses to the pandemic with respect to rental housing and evictions has been mixed. Recently, a U.S. District Court judge for the Northern District of Ohio, J. Philip Calabrese, ruled that the federal CDC moratorium on evictions was not authorized by Congress. The law Calabrese effectively ruled upon is the Public Health Services Act of 1944, a federal law passed by Congress in 1944 under Franklin Delano Roosevelt. Here's the text of some of that law in relevant part. The CDC, with the approval of the Secretary, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. Judge Calabrese's decision was one of the many developments that occurred during the COVID-19 pandemic in the US that affected renters. While Calabrese's decision only has a limited effect initially, mostly in his district, most people are saying, but we shall see, and perhaps in the Q&A, some of that can be discussed. It did highlight the challenges for renters during the pandemic, struggling to maintain their shelter. Judge Calabrese's ruling and opinion is also an example of an opportunity for a member of the federal judicial branch to act decisively to address an international and national problem. Calabrese, however, somehow got detoured into political ideology. There had been one other opinion issue that did not agree with the CDC moratorium, but Judge Calabrese's decision took the bigger step of declaring the moratorium unconstitutional. It was an attempt to invalidate the CDC order nationwide. During the COVID crisis, there were numerous opportunities and moments when various branches of government instituted policies, new laws, and legal rulings that directly impacted the lives of people facing imminent evictions from their homes and apartments. These decisions, like so many others, have proven to be quite impactful. When the COVID-19 pandemic began and hundreds of Michigan consumers began to call our housing clinic seeking answers, there were really no answers. Fortunately, Governor Whitmer issued a temporary stay on all evictions and allowed the Supreme Court of Michigan to act. This allowed the judicial system in Michigan to get a grasp on what lay ahead and to forge their plan. To its credit, Michigan, like many other states, put in place a path forward for its court system and, in particular, evictions. So I will add to that by talking about what happened last summer. So in the summer of 2020, when the first moratorium by Judge Whitmer went into effect, what happened was they expanded that eviction diversion program that I referenced in my notes there. They expanded it to just about to every court. I can't say factually for sure if I am aware that all the courts did that, but that program was put in place. And in fact, the money that individuals could apply for was called Eviction Diversion Program Assistance. That's what it was called last year, and that program ended in January. But that's what it was called, and it worked. That program works just like our traditional eviction diversion program worked. But what the Supreme Court was able to do, and what Governor Whitmer was able to do, she issued an order expanding that program to all the courts. So any court was charged with setting up a program where the tenants had a pretrial. So normally when you go to court and you're sued for eviction, normally when you come to court, you have to have your plan in place. You either have to contest the action right there, or you could get an attorney, and that attorney will come with you and be your attorney. But only like 4 to 5% of tenants actually can get an attorney. I mean, historically, all across the country. So that first date under the current procedure is the date of the trial, basically. So what one good thing they did was, the Supreme Court did, they said, no, that's not going to be the court date. That's going to be the pretrial date. And then judge will set a new date for the hearing. It'll be automatically pushed ahead a week or 2 weeks or 3 weeks. And it started being pushed ahead like 3 weeks or 4 weeks. And to their credit, the landlord attorneys, at least in the counties and the courts where I was operating, they totally understood it. They totally got what was going on, and they worked right along with us. Any of our students will tell you they worked hard on it as well. They worked just as hard as we did to make this happen. They didn't come there saying like, well, you just have to be thrown out, that kind of thing. It wasn't even that. It was the ultimate study in cooperation. I can't say it's like that in all the counties in Michigan or all the courts or in other states, but in Michigan, in Ingham County, and in the Lansing Court and in the Mason Court, the courts we operate in, it was great cooperation. And then we began working with the social services agencies who would actually pay out the funds on behalf of the tenants. And normally, sometimes it would take 4 or 5 weeks. Sometimes it would take 2 weeks. It just depended on how it would work. And that's normally how our eviction diversion program works anyway. However, under COVID-19, I would say that the number of evictions went up like tenfold, I would say. It was where we might come in there and it would be 8 or 9 cases or something like that. It would just be just a huge number of cases. And they couldn't take but so many. The Supreme Court order said you can only take but so many. So, and that's how it functioned, and that's how we've been functioning since last summer. And we had a training program. Judge Allen at the 55th 55th District Court in Mason, did a training program through the Michigan, is it the Judicial Institute? They arranged a nice training. So in Michigan, I teach this course called Housing Law and the Public Interest, and it talks about the three entities in society that function in the housing world: the consumer, the public, the consumer being the public, the government, and then the private, and how they will work together. And this, in at least in Ingham County, it worked the way you would want it to work. It wasn't perfect. Plenty of people still lost their homes, but a lot of people who would have lost their homes did not lose their homes. People actually worked very hard and worked long hours. And I can remember it was like midnight. Our deadline on our first go round was January 6th, eviction diversion program. Money ran out, time ran out. And it was like 11:58, and we all were online on Zoom on 11:58 p.m. at the deadline, and we were still intaking people, because if you got in the intake, that means they could still pay you out even if it was a month later. And we were still taking people in that late. And we, after end, people, we just like all just were on Zoom, we just all clapped, not for ourselves, but that we made the effort, and it actually worked out for a lot of people. And now we're in the stage 2 of this, which is the SIRA program. And it looks like it's going to work out. At least I will say, and to close my remarks here, at least it's probably going to work out pretty good in Michigan, because the Supreme Court has been proactive. And you have a governor who's been proactive from the start. And that's the reason why it worked. And the landlord bar, the landlord attorneys, at least where I am, have been on top of this. And they know it's in their interest to be involved, to advocate for this as well, because it keeps their clients' bottom line afloat, because they also need to have bills to pay. And that's how it works. So that is the basic framework of what I've been doing for, I've been doing it anyway, but since last summer, it's been really, really way more intense than normal, I would say. I would say it's a 7-day-a-week kind of job. I do Zoom on the weekend with attorneys and my students, because we have to talk through the cases and stuff like that. So thank you very much for your attention to that. And I'll try to answer the questions about these constitutional issues. I am pretty opinionated on it, because I think the latest opinion is terrible, but that's just my opinion.
So I really appreciate your remarks. I myself wrote down about 5 or so questions, and we had some questions that came in ahead of time. And a reminder to everyone to please type your question in the chat, and that way I can share it with Professor Gilmore and we can try and get you an answer. So I'm really interested in what you were just describing about the cooperation between the landlord bar and tenants' attorneys, and the fact that the judges seem to get it, and that they're just right, that things seem to be working. And I'm curious, prior to the webinar, you and I had a chance to chat briefly, and we were talking about issues of housing insecurity, along with food insecurity and healthcare insecurity and so forth. You've been doing this work a long time. I remember practicing family law in Suffolk County. So I was in family court with my friends in housing court next door, 200 cases an afternoon, right, of eviction cases. And I'm curious if you think that this cooperation is something that can last beyond COVID, and if you think that there are ways in which perhaps issues of housing security will improve, or perhaps there will be greater housing security post-COVID versus decades of housing insecurity that you have seen.
That's a great question. I almost have trepidation.
That was mine, thanks.
I almost have trepidation answering, but I would just say that the cooperation between the attorneys, legal services of South Central Michigan, MSU, Housing Law Clinic, and all the landlord attorneys in this county has been is solid. It's just very good. We kind of know each other. Maybe it's because it's not a huge city, but it's not a small city. This is not a small metro area by any chance. And also the judges, especially in 55, but 54B court in East Lansing, it's hard to gauge that one because that's a little different. But 55 was from the start on the eviction diversion programs with Judge Boyd, Judge Allen, and now Judge Hillman. They're just 100% behind the whole idea of eviction diversion. They've just always been behind it. They just always been wanting to make it work. And then a few years ago, Judge Alderson, she's the chief judge of the Lansing court, and she started a pilot program. It was going pretty good, and they were contemplating bringing it back. Contemplating bringing it back and doing it again. And then COVID hit, and she was that court was kind of ready to go too. So, and they have new judges down there, a new set of judges, really good judges. All of them down there are really good judges, very fair, very patient. So I think that is, to answer that question, I think that's the reason why that works here. And judges in other jurisdictions who are doing this say that everybody has to be on board, but the court has to be on board. They have to be committed to this. Now, the other question about housing security is, I'm not optimistic about housing security in the future at all. I'm not optimistic because it's really bad already, and I'm not going to say this as a critique of our model, which is basically a laissez-faire, free market model of housing, but that is fundamentally the reason why you're going to have housing security. That is the fundamental basis for it right there. And it's no different from our healthcare challenges, where you have a certain segment of the population which just can't get healthcare because we have a laissez-faire healthcare system. We have a competitive healthcare system, and we have a housing system that is the same. And then in the 80s, there has been a rejection of public housing, subsidized housing, a ideological rejection of it. The federal government doesn't build housing. They don't really care about it too much. They've kind of left that to the private sector. And we have what we have. We have intense housing insecurity all across the country, no matter where you go. I think you can't even afford an apartment unless you work 60 hours, certain people. We can afford an apartment. Professionals and things like that, but the average person is having a tough time affording an apartment. This is renters. I'm only going to speak to renters, because if you own a house, you don't have housing security. So the renters are the ones where it's created. So I'm not optimistic after COVID-19 unless they address the problem that existed before COVID-19. It was terrible before COVID-19, and now it's just an open wound now. Some people we have clients now who never got their job back. And at some point, the unemployment is going to run out. So they're trying to rotate to another income source. They're trying to rotate to another way of working or something like that. Some people caught COVID and they are still suffering from the ravages of it. They couldn't return to work, that kind of thing. So it's a lot of different scenarios, but I'm not optimistic about it unless, one, the federal government says we're gonna take a strong look again about getting involved in this whole idea of subsidized housing, trying to provide more housing in some kind of way. At least the numbers. I could lecture on this for a long time, but there are reasons why the numbers are low, and that has to happen. That has to happen, because I don't even blame the private sector. They just are playing the game the way the game is set up. The game is set up for them to be able to market their housing and charge whatever they want. There's no controls. There's no competition to force them to lower their prices. There's nothing. And I'm not saying any of that should happen, but we're not even looking at it. There's just all it is year after year, everybody complains, and then nothing ever happens. So there you go, right?
So for what it's worth, the conversation is engendering a fair number of questions. So there's a bunch in the chat. I'm going to start to go through them. One question from an alum is if you have seen, and now I'm having difficulty, it's not like I don't Zoom all the time, but I'm having difficulty accessing the chat at the top. So sorry about that, guys. But if you have seen the Amazon Prime show about redlining, which is called Them, I have heard of it. I myself have not watched it, so I can't give you a synopsis.
I have not, but I will promise Tedda Hughes, who's one of my former students who did a great job. I promise Miss Hughes that I will watch it.
All right, we always appreciate a recommendation. Thank you. So the first question that had come in the chat is this something where we're, and I hope I'm understanding the question correctly, but is it that we need to keep pursuing these eviction cases one at a time, right? Which is what you described. I believe you said as many as 15 agreements per week, right? I know the caseload is very high. Or is there some kind of broader systemic change that could improve the system so that you wouldn't be dealing with the kinds of high caseloads that we were talking about?
It's hard to say because the Supreme Court did put a limit on the cases, the number that they were calling. And I did notice that one of the questions there, they're asking about the landlords who know that the person is behind and they want to try to access the funds. The system is supposed to be automated now. It's supposed to be. Don't crash me over the head if it's not, because I don't run the MISTA. MISTA is is the State Housing Authority. But that's supposed to be automated where the landlord and the tenant can apply at the same time and put their applications in, and then that will start the process, and then things will move along much faster. You might not even you don't have to go to court, put it like that. You don't have to sue anybody to access the SERA system. So that's one thing I think if that system gets up and running, the landlord probably would need to talk to their tenants, especially the small landlords, talk to the tenants and say, come by my office and you can log on my computer and we'll do our applications together, that kind of thing. I think it's fair for me to say that without that being legal advice to anybody. But that is one way that they were doing it in person. But that in-person thing is over with. And I think they were concerned about, and there was a big outbreak of COVID at one of the providers. So I think they said we can't have that anymore. So the landlords, I would encourage the landlords to get their tenants to come in and sit down and get them to go through the application and do it all together right there. And that'll save everybody like 2 or 3 weeks, to tell you the truth. So that's the answer to that. I think you were saying like why one at a time, and I think the court has put a limit on the number of cases. That's the reason why sometimes they move kind of slow, and they are months behind, I would say, because when they started, they shut down in March, and there were a bunch of cases pending that went back to December of 2019. Just understand how crazy that was. So then they had moratoriums until like that summer. And then that's when the Supreme Court of Michigan said, okay, we're ready to go. Here's how you're going to proceed. And then they started working those cases. So the first cases we got were like January of 2020. And this is 6 months later. So I don't know if they've caught up, but the cases continually getting filed, I can say that. And then some people have been through the system twice, which is crazy. I mean, they got a payout, and then now they're back in the system again because they don't make enough money to keep paying. So it really is as you suggested in one of your questions, it really is something, this is not a solution. You understand what I mean? The EDP program, the SERA program, these are not solutions. These are stopgap measures. So you won't have, and you and I have had conversations, so you won't have Les Miserables on the streets. You'll have hundreds of people living in tents because they all got put out. And then you'll have landlords losing buildings because they couldn't even generate enough income to keep their buildings going. So that's what this is, but there's a larger problem here. And I think it is valid to say that these cases are backed up. They're severely backed up, I would say.
So I really appreciate you giving that perspective, adding that lens of the landlord, because one of the things that I was thinking about when you first started talking about the affidavit that's necessary for tenants to complete to even benefit from the CDC moratorium is, how would people know, right? Not, okay, yes, plenty of tenants are reading the newspaper or watching the news, but plenty of tenants who are desperately scrambling for every penny to put some food on the table or to stay in an apartment may not be aware. We also know that many individuals may have literacy issues or may not even know how to complete an affidavit and so forth. So is it that you think these particular programs are working because the landlord is trying to encourage the tenant, or are there other mechanisms by which tenants are being made aware of these emergency measures?
That's another great question. And I do not know how, if they come to court, the judge is going to ask them, do they want an attorney? Sometimes the judge might say, did you fill out a CDC affidavit? They might ask that question because there at one point there was a penalty if a landlord filed a case and that moratorium affidavit had been submitted to them. So I don't know how people are finding out. We tell them immediately. When legal services tells them immediately. I will say that there is a phenomenon in states across the country. Nebraska was one of them, where they discovered that they did a study and 60 evictions occurred. And they looked, and all of these individuals were eligible for rental assistance. They were eligible for the CDC moratorium, and yet they were still evicted. They never invoked their right to the CDC protection. They never said, I would like a lawyer to help walk me through the process to get rental assistance. Nothing ever happened, and 60 evictions occurred. So you just don't know what's out there. And there are evictions that have occurred like that probably in Michigan. For me personally, the vast majority of what I see is the landlords and the landlord attorneys are playing the game above board. Like, in fact, they're making a business decision that it is in my interest to keep this tenant who was doing fine before this all happened. But I do need I do need the rent to come out and so I can keep my own situation going. But I can tell you that I don't know how they find out, except maybe through a social service agency. If they that's not even their concern. Their concern is to try to get them the assistance. This is like MISHDA and MDHHS, all of those, Holy Cross, Capital Area Housing Partnership, Advent House, all of those organizations are mainly focused on the rent. They're not focused on the legal part. They leave that to us. So if they get to us or legal services, they'll probably file that affidavit that day, and then that'll stop the case. But if they don't, you just don't know what's going to happen. You don't. And then we've had a few landlords have challenged affidavits in court and have to have a hearing, but that's okay. That doesn't bother me in the least. I mean, you want the system to work, so if they feel like there's an issue, go ahead. So
yeah. So two questions I'll pose to you, because I think one is short and then one might be a little longer. So one is whether you plan to update the landlord tenant handbook to reflect these current COVID issues. I think you're going to have to ask the dean for a research assistant to help, because I don't know that you have enough free time.
That sounds like a great project for
So,
somebody.
I think the dean is going to support that.
That is
And then,
Heather Lamb was also his former student. So hello, Heather.
so that was a great question. And then the question of, does Sarah apply to trespassers in housing at all during this moratorium? So I hope I'm conveying the question.
I would say for that question, probably not, unless if they're a trespasser, meaning like they just took up refuge in a property and they were never a renter. They probably wouldn't be able to establish themselves as a renter. So you have to have the landlord to say, yeah, they rented from me, even if it's on a month to month, even if they just show a receipt, that kind of thing. Or if they sue them in court and say, yeah, they were a renter and they didn't leave, and I consider them a trespasser, because that's what a holdover tenant almost is anyway, in a certain way, is a person who didn't leave at the end of the lease. But if this is somebody who just shacked up in your spot, then probably not. You probably would just terminate and then give them a 30-day notice, and then you probably, and the CDC moratorium does not apply to people who just have shacked up in somebody's spot, but they can't get any rent money anyway. So
right,
that's a tough one there. But if the landlord said, yes, they are a renter, they are my tenant, probably can. So I hope I'm not opening up a loophole of fraud there.
So prior to the webinar, we did receive some questions. One, you started to address it, but you said that you might have some more thoughts on it. And I did want to come back to the constitutionality of the CDC eviction moratorium, because that is starting, as you point out, to get some attention. Right.
So the CDC moratorium, a lot of people say, is it constitutional? Is it constitutional? And the short answer to that is nobody knows right now, because at first the state courts were mostly upholding it. They were abiding by it. They were staying the cases. Then they had a federal case called Azar. The HHS director was sued. That case, they upheld the CDC moratorium, and then you had a few others. But then you had a case in Texas. I forgot the name of that case. I think it was called Tiger Lily. And then a case in Ohio, which is more famous, called Skyworks. Skyworks is the case with the judge Calabrese, who said it was unconstitutional. And he basically said that no court should, but he basically tried to get it declared unconstitutional nationwide. The Department of Justice is appealing it. And so in the Northern District of Ohio, where he is, more than likely the state courts are probably going to have to ignore the CDC moratorium in that area. Michigan, as I said, has put in another layer of protection for tenants. It's not a crazy serious layer, but it just says if you come to court and you say, I have applied for SERA funds, you automatically get a stay for 30 to 45 days. So Michigan, I'm not saying they're ignoring that latest case. They're just saying, this is how we're going to handle it. And they're not even going to bother with worrying about the CDC moratorium for now. They're just going to operate under that function. But Michigan was also recognizing the CDC moratorium, and they were abiding by it. I feel like Calabrese's decision is a serious overreach, and he completely ignores the law that he's commenting on, the Public Health Services Act of 1944. If you go back and read that law, if you go back and read the literature that was written at the time the law was passed, I think his decision is lost in ideology. And I said that in my comments, trying to be as respectful as possible. But the law even says The law even quotes severe acute respiratory infections is one of the things that the law Congress gives the agency authority to try to prevent and stop the spread of. And I can't see how you can write an opinion that says they want to stop evictions, and science has proven that evictions can spread these SARS, severe acute respiratory is SARS. This is just it's just happened a long time ago. And that's all it really is the same virus that causes the common cold. And now these are new SARS viruses. They're different, much more vicious, much more lethal. And so I don't see how that is mentioned in the law, and I can't see how you are going to say that Congress didn't extend that power to the Center for Disease Control. I just don't. I've read the decision many times. I don't see it. I just think that it's just an ideological decision. I mean, we have a lot of that lately, but that's just my opinion.
So you mentioned, if I heard you right, that eviction cases have really multiplied so much since COVID started affecting our lives. We've been in this pandemic over a year, and I know for some of us, maybe I'm projecting, but I feel like it's been a decade, right? We're just sort of lost in time. But the number of eviction cases has absolutely multiplied. The CDC moratorium at this point is set to expire in June, if I understand correctly.
Right.
So then what happens, right? What's going to happen in July? If your caseload has already exploded, what comes next?
Yeah, so once again, that's a good question. I'm assuming hopefully that the government, the state and the federal governments are hoping that that these numbers will begin to come down and the spread will come down. And so the science behind the evictions, of course, is people get evicted and then they're on the street and they're interacting with people when they shouldn't be interacting with people, or they're doubling and tripling up with people, family members, and then the virus is spreading all over the place. So we have like 2 or 3 months here to try to get this under control, so maybe that science will improve. But and that's really the only tool they have. I mean, I don't think the evictions are going to slow down. The reason why I know that is because the Supreme Court of Michigan has these maximum limits on the number of new cases that can be brought. Like the judges, I don't know what it is, but it's something like 12 in some courts, and it's like 24 in some courts. So when I go to court every time, every slot is filled. And then if you can hear the judge saying, the attorneys will ask for a slot and they'll say, then you can't get that slot. Because what they mean is all the slots are taken for that day, so you got to bounce to the next day. So at some point, the Supreme Court will probably take a look back at the science and see if the numbers are down. One of the good news is, of course, the report yesterday was that elderly residents of nursing homes, the numbers are decreasing, which is, they were the first ones vaccinated. So that means that the vaccine works. So now it's just a matter of the next group seeing if their numbers come down. And that's really all you really can do at this point. Joe Biden, the president, said he wanted the CDC moratorium in place till September. I really think that Joe Biden should have just issued some other, a better order than the one we had. That is a carryover from the Trump administration. It always had a lot of problems to it. It lacked teeth. All of us said it did, but he keeps extending basically the same moratorium order, which me personally, I think is a mistake. I do. I think it's a mistake. I don't think it's a mistake to let the system go forward the way it is in Michigan. Michigan is even allowing landlords to file their cases. They don't say because it's a moratorium you can't file cases. No, they say file your cases, and when it comes off, then you can take your action if things haven't been resolved. But we assume that things will some things will be resolved. But that's what I think should happen. I think Biden is probably going to have to extend it. He said he wanted to extend it till September. He said that at the inauguration.
Well, and that was really what was prompting my question. I mean, of course, Michigan seems to be making national news on a regular basis because our COVID numbers have been awful. Um, but I'm an optimist, as you know, so I'm optimistic that things will improve here. But what concerns me is, putting the COVID piece aside, if the moratorium on evictions ends, are we just going to see an explosion in homelessness come summer of 2021? Because even though the economy is rebounding in some aspects, we also know that there are many sectors where people are, they've left the workforce. They're not looking for work. We haven't figured out what to do with children who are in virtual school, or children who can't be vaccinated, or so forth. And I know I've been hearing a lot of reports about the disconnect between employers looking for employees,
Right.
yet individuals who don't have resources, or don't have the opportunity to look for work. And I'm just wondering what you think the future holds. As I said, I was an optimist, but I have to say, in this regard, I'm a bit pessimistic. And so I'm just wondering if you have anything.
I would say I'm sort of optimistic. I am in a certain respect, because I think that, I'm a child of the vaccination era, so I remember standing in line, and I think vaccines work. I mean, I'm not a scientist, but I got vaccinated for a lot of things, and I didn't get any of them. So I can say that I think if people cooperate on the vaccine, I mean, I'm okay with your view that you don't want to take one, but I think if most people cooperate on the vaccine and let this happen, we can, I won't say get back to normal, but we can stop this public health problem kind of like in its tracks, so to speak. And I think it is working. I think the numbers on the nursing homes indicate that, yeah. So once it goes down the line, then I think it's going to be better. But those scientific numbers on overcrowding and homelessness spreading COVID-19, those numbers should wake people up, because right after they lifted the moratoriums in the summer of last year was when the numbers began to shoot up. And that's what prompted them to put the national moratorium in place, because before it was just a patchwork. It was just a patchwork of Michigan had a moratorium, but this state didn't have one. And Nebraska didn't have one, but this state had one. And some of the moratoriums came off. That was a patchwork. And once the national one went in place, that was important. So, but those numbers from that study should wake people up. I mean, to me, there are clear that overcrowding, homelessness, which come from evictions, leads to more cases and more deaths. I mean, you can't make it more plain than that.
So it is 8 o'clock, and this hour has gone very quickly. I want to thank you, Professor Gilmore, because this has just been a fabulous conversation. I know I learned a lot. I also want to thank you for the tremendous work that you do, your advocacy, which is so important to the community. But I also note the comments in the chat and how many of your former students wanted to join this evening. And it's a real compliment to you, not only as an advocate, but also as a professor. So thank you for doing a great job of teaching us this evening. And thank you to everyone for joining us.
Thanks everybody for coming out.